Welcome back to the show, everybody. We got a great one lined up for you here. I tell you what, we got the Fed today in more ways than one. You're going to want it. And we're going to talk about making the case for Ripple XRP to go to the Supreme Court today is the conversation mainly. James Murphy, a former securities lawyer litigator, is going to join us in this conversation as well. I have a crazy fire interview I did with him that I will be releasing later today, but I've got clips you need to see. I'll tell you what else we got. Binance auditors, looks like trouble over there. Warren Davidson, SBF's timely arrest. We're going to talk about that. And how about this? We got breaking news in the LBRY case. Amicus Curiae joining over there. You won't believe who it is and why it's happening. Somebody roll that beautiful intro.
Digital Perspectives with Brad Kimes. Come on in.
Welcome back to the show, everybody. You can follow us on TikTok, YouTube, and Twitter for exclusive content. $862 billion market cap for cryptocurrency. We are off by 3.7% this morning. And good morning to you. 17,000 slightly over for Bitcoin right now. Ethereum 1,200 plus. And we're looking at the market cap of Tether at 66, almost flat billion right there. Keep an eye on that. That's why we're watching it. 36 cents per XRP right now. We're off by 7.5% on the 7-day. Careful what we call progress, ladies and gentlemen. We're going to talk about some things today that I think will help us all understand, and at least remind us down memory lane why we're here, how we got here. But until then, let's take a look at this very quickly here. Ed Grad Crypto reminds us, and shout out to him, give him a follow. The Fed won't stop. Talking about Jerome Powell. Won't stop until he breaks the economy, essentially. And we're talking about the initial claims here showing from the CBO and how we could be looking at this breakout to go to numbers go back way up again. It's just, I tell you, I see things like this, and I do feel like there has been a postponed recession that probably we should have felt in 2020, but then we had the pandemic, and then they shut that down, and then they started printing money, so it deferred the moment that I believe still awaits us. And that's why I'm accumulating gold. It's not financial advice, but I was a customer before they were a sponsor, and I love what they do. And I don't have enough, and I want to continue to accumulate. It is your physically allocated gold. It is not paper gold. And you get enough of it, you can have it sent to you as well. So keep that in mind. But more importantly, you also get access to your account and your gold, which you can spend like money with your MasterCard debit card. Click the link underneath the video. I'm telling you, once you start using it, having it, you'll be very glad you did. This is a reminder here, and shout out to Mr. Hubert, who does so much incredible work for all of us out here. This is Bill Hinman. He was your director at the SEC. He received $15 million from a member of the Enterprise Ethereum Alliance. Your ethics office warned him that he was criminal financial conflicts. He ignored it and gave a speech that created a regulatory monopoly for Ethereum. Boom. There you have it. The facts are not in dispute, ladies and gentlemen. ETHgate and the free pass are very, very real. They really are. Don't forget it. This here is Warren Davidson. Now, it's back and forth with this guy sometimes, but you know what? We're on it today. We align today, and for that, we'll talk about this. He talks about why he believes SBF was arrested, and I believe it is exactly for the reason I mentioned here, that if SBF showed up, I bet he would have talked about the political donations in the SEC and CFTC meetings for the entire testimony, or at least if I was SBF, that's what the hell I would have done. And isn't it strange that he gets arrested just in time to not do exactly that?
Research which looks like has commingled funds with FTX.
Yeah, and not just Alameda Research, but Sam Bankman-Fried himself. And I think that's a big part of the timing, frankly. I mean, it's all speculation at this point, but the best theory I have is that the SEC and others didn't want SBF to give his own version of, so what were you doing with Gary Gensler in the Securities and Exchange Commission with all these meetings and all this interaction that you've had with regulators? And he would have been able to give his side of that. The regulators, the SEC, Gary Gensler and others wouldn't have been able to filter the questions, and they didn't know where that was going to go. So I think that's part of what drove some of the timing on the arrest.
SBF, had been asked to testify.
That's exactly
hours
right.
before
Let me
he's
stop
arrested.
this right here. I think that is absolutely spot on, and it looks like more trouble. And I hate to say it, I don't want to. I like CZ. Seems like a really great guy. First exchange I was ever on was Binance. There's a fun fact, right? I love that exchange too. I missed it. I remember when they told us we had to get off of it. I was so bummed out. I didn't know what to do. But we're seeing another moment like that. But you know what? Binance auditors, Mazars, just quietly nuked the website containing Binance's so-called proof of liabilities. This is not good, ladies and gentlemen. You see this post right here. And then you go over to here, and it's no longer there. And this is what was there. Yeah, I was not impressed, I have to say, with the responses from CZ. Just telling somebody you'll be fine isn't good enough. I mean, why don't you just have that third-party legitimate audit done? And if you don't, it's always going to be questions. Let's take a look at this very quickly. Some minor news in the SEC versus Ripple case. Attorney Rodrigo Sierra has filed a motion to appear pro hac vice on behalf of amicus curiae Paradigm Operations. That's the end of it right there. So basically, according to Jeremy Hogan, it's just an attorney for amicus brief filing a request with the court to be able to file stuff in the case. Seems pointless at this point since there's not much to be done. Appreciate his insight on that. And we appreciate this guy too. And again, I'm going to tell you, I got a full interview I'm going to release today with James Murphy. And we're going to talk about FTX and the bankruptcy and the criminal actions that went on. He's going to talk about the SEC versus Ripple case and the possibility of it going to appellate and Supreme Court level. Oh my goodness. But until then, let's talk about this guy and what he's done for this amazing XRP army. And listen to the nod that James Murphy, 30-year securities lawyer litigator, giving all of us the nod. Shout out to you, James. It's such a wonderful conversation.
So my hat's off. And then this guy, John Deaton, I was thrilled when he comes in with, hey, look, you see this army? They don't believe they're victims, except victims of the SEC attack on this community. Brilliant, because the judge would not know that without that having happened. You could have an amicus brief thrown in from a few people saying, hey, I bought XRP with this in mind, and I didn't think it was going to, here was my motivation, blah, blah, blah. So what? You can find a few people to say anything, but having this huge class of people saying, hey, SEC, please stop. Hey, judge, tell the SEC, please stop. Brilliant. Absolutely brilliant move. So my hat.
And there you go right there. And shout out to John Deaton. And another brilliant move has been made again. This here from Jim telling all of us that in the LBRY case, John Deaton and attorney Bill Gannon have requested to file amicus brief. But it's very important to understand why in the LBRY case. Remember, that's the First Circuit Court, not the Second Circuit Court. And we don't want to confuse the understanding. John Deaton has made it very clear for us, and so did James Murphy again, that those are two different courts in the other conversation we had. But those are two different courts, and it doesn't set precedent for the Second Circuit. But, however, there's key things to understand about this. No, this is in representation of Naomi Brockwell here, and on behalf of herself and similarly the LBC token holders respectfully request the court to grant her leave to file proposed amicus brief here too, and that is obviously how you're going to see the involvement of John Deaton and Bill Gannon in this thing. Here's what we need to know. It seems the holdup with this case was secondary sale distinction. Take a look. This is why it matters here. However, the court's order failed to distinguish among the sales that were made to purchasers that a bona fide consumptive intent and those who were offered and who purchased LBC tokens with a reasonable expectation of profit from the efforts of LBRY themselves. What's interesting about all of this, and shout out to Sherry and Empress for this, what's interesting about this is that Naomi Brockwell did not buy or sell or trade any LBC tokens, even though she used the platform itself. So that doesn't meet a Howey prong. Gets very interesting here. So the token itself is never the security is the argument here. There's no case law from the Supreme Court or any appellate court that analyzes whether an underlying asset of an investment contract is itself a security. The reason there is no precedent is because the underlying asset utilized in an investment contract transaction is never the security. And as you know, if it was, then the oranges themselves would be securities, right? So here you have this where it says, now this is mega important that a distinction between early sales and secondary sales is an actual issue. Naomi Brockwell, having never sold or purchased the LBRY token, yet operates a channel through the platform, is a problem for the SEC argument on a permanent injunction being proper. So if you look at this very quickly here, not only did Brockwell not acquire LBC from LBRY or its executives, she has never sold or purchased a single LBC token. Considering the Brockwell acquired the LBC through her channel and was unaware that the tokens had monetary value, the SEC must concede that the first prong of Howey could never be satisfied. Finally, any tipping or benefit that she did receive was solely due to her own efforts. This is a really important moment they are intervening on right here, ladies and gentlemen. Critical that the court distinguish secondary market sales, which is retail investor sales. First Circuit, Second Court, Circuit, 800 Circuit. It's all important. This secondary sales not being securities is an important issue on every level. I do understand that, and I know you guys do too. Once a security, not always a security. If the court issues injunctive relief, it is critical that the court distinguish secondary market transactions. Even if LBC was offered and sold by LBRY as an unregistered security, the next subsequent transfer or sale of the LBC does not equal the same. This distinction between offer and sale transactions and the underlying crypto assets is critical because facts and so on, right? So obviously it really comes down to the idea and understanding that if you make the asset securities, then you make oranges securities. And how about this? James Murphy again. I'm telling you, you're going to want to see this interview I'm going to release today. James, what a wonderful conversation we had. You guys are going to want every single bit of it, especially on a Friday. How about SEC versus Ripple goes to the Supreme Court? Listen to Meta Lawman, give him a follow, gives XRP-LBRY the nod for being such a smart community. The Ripple team executives made some really smart decisions when the SEC came after them.
Does appear to make a ruling in that case. However, you made a mention about something on another interview, and you had talked about the possibility of it going to an appellate court and maybe even the Supreme Court. And that is something we've entertained here. And could you just talk about that a little bit, James?
Yeah, I can. And I'll tell you what, I have just been incredibly impressed by this XRP, I use the term army, and how knowledgeable this group is. You say you're not a lawyer. I have seen debates about really sophisticated legal points by people who are obviously not lawyers, but incredibly knowledgeable about this Ripple case. In fact, I was a little intimidated coming on the show because you guys know more than I do about some of the finer points of these arguments. So kudos to all of you. You know, you've really put in the time to have an informed opinion. There are a lot of opinions out there about a lot of things on Twitter and YouTube and whatever, but it seems like this XRP army had put in the work to learn what they were talking about and to have a grounded opinion. So now I'm going to answer your question, but before I do that, I have to say, I am a lawyer. This is not legal advice, and it's certainly not financial advice. I don't own XRP. I'm certainly not short XRP. I have no position and would not make any kind of recommendation. However, here's what I would say. The Ripple people, Ripple and the executives made some really, really smart decisions when the SEC came after them. They hired the right lawyers. They signaled, this is not just important, this is everything to us. We do not care how much this is going to cost. We will fight you tooth and nail all the way. The SEC normally doesn't get that. They normally get people to settle. They pound on, people talk tough at the beginning, then they start having to pay the legal fees. Believe me, I'm speaking from experience on this. And then after a few months, they're like, I can't take it. I tap out. What do they want? I'm going to settle. I have to settle, So look, these guys hired the right lawyers who were there at the SEC, know how these decisions are made, know what the strategy is, know what the documents are that exist within the SEC around decision making. It's just was brilliant. And I can tell you, people like me who spent our lives in the defense bar were thinking, wow, finally somebody's going to fight them on something that's really, really important. Just a quick aside, one of the reasons even really well-financed companies don't fight when we're talking about public companies that are listed on NASDAQ or the New York Stock Exchange, they've got to deal with the SEC every day. They got to deal with corporate finance, or 10Q, 10Ks, audits, proxy, so-and-so wants to put this on the proxy. You kind of have to have a cooperative relationship with the SEC if you want to be a public company. And so that also contributes to this settle mentality. So my hat's off. And then
this conversation continued and it just gets deeper and better. It is such an incredible. I hope you go watch that full interview when I post it later today, ladies and gentlemen. And to speak to that and the idea of, that the case could in fact go all the way to the Supreme Court doesn't necessarily imply that XRP would be stuck where it is today. Now, certainly that could happen right in the US, but remember that there is 95% of the customer base for Ripple is on the other side of the world. And there's a lot of companies using XRP for real purpose and real use case already today. So that to me keeps me encouraged. But if I go back to 2020 when this case was filed, this is what Stuart Alderati wrote himself on Twitter. He said in 2015, the U.S. government concluded XRP was a virtual currency, and that was through the FinCEN decision, which we've covered here plenty. Last I checked, the SEC is still a part of the U.S. government. Here's the plus side. The industry will finally get the clarity it deserves. Goodbye Howey test. Hello, Ripple test. That is the suggestion from the Ripple General Counsel. Howey test was derived from going all the way to the Supreme Court. To me, I take what he says here. If we're going to have something that is legitimate, legally bona fide as the Howey test, the Ripple test may just go to the Supreme Court too. And here's a few things to leave a note on. And why wouldn't it? The Federal Reserve is developing a real-time gross settlement system, right? And Ripple is already a part of the Faster Payments Council to do exactly that. You can see the evidence right here. Faster Payments Council and Ripple have launched a crypto payment survey designed to gauge the industry perspectives on the use of blockchain and cryptocurrencies in payments. The Digital Dollar Project, as of September of this year, right? Just last September, the Digital Dollar Project will be working with crypto companies like Ripple and Digital Asset.com on a new sandbox program to evaluate technical, business, and policy approaches to a U.S. CBDC. You tell me. And I see that kind of weight. What I start thinking about is what David Schwartz has talked about that we covered here as well. When the internet was derived and born, It was adopted by governments and military first, then people, citizens, retail users. This has been the opposite. This has not been adopted by governments yet, but from the looks of this thread, it's soon to be. And from the looks of this thread, Ripple's going to be smack dab in the middle of it. And then looking at this chart very quickly before we get out of here from XRP Crypto, it just happens to line up at about the March timeframe where Jim Filan keeps telling us this case may run right up to before we get the ruling we're looking for. And will it break up or break down? I don't know. But I tell you what I do know, and shout out to XRP Crypto for this chart. When I start to see technical fundamentals or technical news and fundamental news start to align, that is one window of opportunity I want to pay very close attention to. It's not financial advice from me or anyone else. I couldn't be more excited where this case is for me personally. Even though I won it over yesterday, we're a lot further along than the rest of the crypto space, and that's just how I have to see it. That's going to do it for me. Make sure you check out all the links underneath the video. I'll catch all of you on the next one.